Good morning, everyone. Let's talk about the work permit for the spouses and common law partners of international students in Canada. Just to begin with, let me introduce myself. My name is Al Parsai. I'm a regulated Canadian immigration consultant. I have been practicing for the past almost 11 years. I started my business, independent business, in January 2011. And I'm also a teacher at Ashton College, and I'm an adjunct professor at Queen's Law School. I teach immigration to those people who want to become practitioners. I'm also the author of the book 88 Tips on Immigration to Canada, which has been identified as the bestseller book by Amazon.ca under the immigration law. So what I'm going to do in this series of my videos, since I have a very busy schedule and I haven't been able to record videos in the past few months, I have decided to go live every now and again when I get the chance and discuss a topic in relationship to immigration to Canada. And for those of you who become live, if you have any questions after I'm done with my short topic, I will happily answer your question depending on the time limits that I have. So if you're live, please stay tuned. I will talk about IMP C42 right now. And then after that, if you have any questions, I'd be more than happy to answer those questions as well at the end of this video. Hello to all of you who have joined us. So the first thing first is that if you are an international student in Canada, then as an international student who studies at a post diploma or post graduate or undergraduate program, in any post-secondary program that is at the designated learning institution, and you're studying full-time, by default, you may work in Canada part-time. So you may work up to 20 hours per week, and during the regular breaks of the school, you may even work full-time. So this is great. But what about your spouse or common law partner? If you have a spouse or a common law partner, then your spouse or common law partner may also apply for an open work permit under an LMIA exemption code called IMP C42. I want to explain IMP C42 in more details. But first, let's understand what is an open work permit. Open work permit means that you can come to Canada and pretty much work for any employer in Canada. However, the officer may impose certain limitations on your work permit. For example, they could say that you are not allowed to work outside a specific geographical location. Let's say you move to Toronto, where our office is at, and you receive an open work permit for Toronto. This means that you cannot work outside Toronto. And also, they may impose other limitations. For example, people who have work permits in Canada, they are not allowed to work for adult industry inside Canada. Also, if you have not done your upfront medical exam, and I will post a link about upfront medical exam below this video, then this means that you are not allowed to work in schools or at healthcare facilities. Beyond that, open work permit is an amazing opportunity for a person to come to Canada, work, gain Canadian experience, and hopefully even immigrate to Canada. And this is possible under a public policy under Section 205 of the immigration regulations, which that public policy says when an international student comes to Canada, then it is on humanitarian basis justified that the immigration authorities issue an open work permit for their spouse or common law partner. So that spouse or common law partner can live with you in Canada and also work full-time, and of course provide for the family as well, and hopefully, as I mentioned, eventually immigrate to Canada. However, to make sure of the integrity of the system, the immigration authorities had put some requirements for this kind of work permit. And they also tightened the requirements on September 16th, 2021. So if you're applying on or after September 16th, 2021 for an open work permit for the spouse or common law partner, you need to keep this in mind, the requirements that I'm telling you. First of all, obviously, you need to show that you are in a genuine relationship with the international student. And genuine relationship, it means that you are genuinely a spouse or common law partner. Because under Section 4 of the immigration regulations, if somebody gets involved in a relationship just primarily to get a status in Canada, then that person is not considered a common law partner, is not considered a spouse, and in fact, it's not considered a family member, and therefore you do not qualify for this work permit. How do you prove your genuine relationship? So if you are in relationship for more than 2 years, or if you have been in relationship and you also have common children together, then it is very easy to prove that this relationship has not been for the purpose of working in Canada, getting status in Canada. You have been in a relationship for more than 2 years, you have children together, then it's very easy to prove that. By the way, this 2 year is based on my personal experience. It's not a guideline by the immigration authorities. But if your relationship is less than 2 years, I highly recommend and you provide more documentation. For example, support letters from family members that they say this relationship is genuine, pictures of you and your spouse being in different locations together, to parties, to traveling, etc., etc. So if your relationship began less than 2 years ago and you don't have children together, make sure to provide more documentation to prove that your relationship is genuine. For those of you that you are tuning right now, just to let you know, I will answer your questions after I'm done with my live session. And this live session is about open work permit under IMP C42, which is a work permit for the spouses and common law partners of international students. Okay, so genuine relationship is important to show that you have been common law partners or spouses. By the way, common law partner, it means that you have cohabited for at least 1 year. And this means that you live together under the same roof. And of course, your relationship is emotional, intimate, and you are financially related to each other. But when you're spouses, it means that you are married and your marriage is approved by the jurisdiction that you got married. Now, in terms of the international student, they also expect something. The international student must be studying at a DLI or designated learning institution. They must have a valid study permit. They must be actively studying inside Canada. They also need to show that they are a full-time student. And on top of that, the program that they are taking must be a PGWP approved program. So in other words, they are studying at a postgraduate work permit approved program. What is a postgraduate work permit approved program? It's a program that if you graduate from that program, later you may apply for an open work permit. Now, if you're studying at the university level, it's very likely that your program is PGWP approved. If you're studying at a community college, which means government funded colleges, then it's very likely that your program is PGWP approved. However, if you're studying at a private college in Canada, then it is almost certain that your program is not approved for PGWP. So you have to be very careful. The international student who wants their spouse or common law partner be able to receive an open work permit in Canada, other than proving that the relationship is genuine, they also must register to a program that is approved or could be approved for postgraduate work permit. How can you find out if your program is approved for postgraduate work permit? When I'm done with this live session, I will post a link below this video that will guide you to the list of schools in Canada. You can enter the name of your school, and based on that, you will find out whether it is approved for postgraduate work permit or not. So these are the main requirements for IMP C42, but keep that in mind that if you are qualified for IMP C42, it doesn't mean that the officer will also issue the work permit, because the issuance of work permit is not just based on that exemption. The exemption says that you don't need a labor market impact assessment report from ESTC or Service Canada to apply for this work permit. It doesn't go beyond that. Beyond that is Section 200 of the immigration regulations. Under Section 200 of the immigration regulations, you need to meet certain requirements. Specifically, 201B says that you need to convince the immigration officer that by the end of your authorized stay in Canada, you will leave Canada. And for that, you need to show that you have strong family ties back home, or job prospects back home, or your financial status shows that you go back home. A combination of all different documentation. Obviously, depending on your nationality, if you are coming from a country that they are visa exempt, then 201B will be less important to the immigration officer. But if you're coming from a country that needs visas to Canada, then you need to include strong documentation to prove that you meet all the requirements under Section 200 of the regulations. Obviously, if you're interested to hire me and my team, we will be more than happy to help you with your IMP C42 applications. And we have assisted literally hundreds of people with their work permit applications. About 60-70% of my business is dedicated to work permit applications. So if you get in touch with us, we can evaluate you and we can help you with your work permit applications. So that's enough talking about IMP C42. I have an article about IMP C42 if you're interested. I will post the link below this video after I'm done with this live session, and you can click on that link and read the article as well for more details about this exciting program. Now let's go to the questions. I will dedicate about 5 minutes to questions because I have another live session on Instagram, and I will promise to come back and deliver more short videos about different aspects of immigration to Canada. Okay, so let's go with the question. So Kartik says, how are you? Fine, thank you. Yannick says, hi sir, hi. Okay, Kartik says, my passport is in IRCC New Delhi since 20th of October. For stamping, everyone's passport is returned within 1 week. I had applied to withdraw my application, for which I got passport request, but after passport got received in IRCC New Delhi, I got withdrawal confirmation and visa confirmation for second file. The same night I got withdrawal confirmation, I got visa confirmation on second application. So honestly, Kartik, what I can tell you, first of all, I don't know the specifics of your case, obviously, but generally speaking, these kinds of things could potentially happen, unfortunately. And honestly, I don't know how they will handle your case. Sometimes they mix up. I have a story to tell you. I had a client long time ago from the Philippines. She was living in Canada, and we applied for a multiple entry visa for her. At the time, we submitted the application to the visa office. At that time, it was a long time ago, you had to do everything in paper. So we sent the application to the visa office. And guess what? While we were waiting for the visa, my client became a permanent resident of Canada. She got approved. She was invited to an inland office to become permanent resident. I got in touch with the visa office. I informed them about the situation and told them that my client doesn't need the visa anymore. And at that time, the processing fee was $150. Nowadays, it's $100. And I asked for a refund of the processing fee and not processing the application. Guess what? The officer returned the passport to our office. The visa sticker was inside the passport. And on my letter, they sent me a smiley face. So unfortunately, they charged my client $150. They issued my client a multiple entry visa. But in fact, my client was a permanent resident of Canada. So in other words, they issued a multiple entry visa for somebody who was a permanent resident of Canada. Now, if you have withdrawn your first application and you got approved for the second application and your passport was stuck in the IRCC office for the first option, they may still continue processing it. But if an officer notices what happened in between, they will correct it and they will affix the right sticker in your passport. Let's keep our fingers crossed that this is what is going to happen. But they are human beings. They might make mistakes. I don't know what's going to happen to your case. So the next question is from Kenny. Hello, sir. How long will it take to come credential email once applied to PR approved email? So it's usually pretty quick. They usually process it in a matter of a couple of days. For example, one of my clients received their letters last week, and 3 days ago, they received their PR. I have another client that received his approval yesterday. So maybe the next live session that I have, I will tell you when they got it. But I can tell you that most of the time, when you send the email, they will give you access to the portal. And then when you go on the portal and you provide information that you are actually inside Canada, you upload your photo, everything is in place. In a matter of a couple of days, they issue the ECOPR, or Electronic Confirmation of Permanent Residence. You become a permanent resident of Canada. Also, if you have applied online, for example, on Express Entry, if you go on your profile, you will see that they actually affix the ECOPR to your profile, and you can see it that you are approved. So it should be very quick. In most cases, in a matter of a couple of days. I had one client that there was a mix-up in getting back and forth with the officers, but eventually they processed the application. But even with that client, it took about 1 week. Okay, so the next question is from Yannick. Sir, my employer have applied for LMIA on 1st of October and have not heard anything yet. When can we expect the result? It's under lower wage category. So it's up to the officers, but usually they nowadays they are, because you apply, if you have applied by email, usually within 3 weeks to 1 month, they get back to you with a letter that explain if there are any issues or if they have any questions, etc. Especially if something goes wrong, they will usually get in touch with you anywhere between 2 to 4 weeks. So my suggestion is that if it has been October 1st, your employer gives a call to them and follow up on your case to see if it's still in process or if they have discarded it, or if there was something wrong. Because usually you should hear from them after 1.5 months. Something. It doesn't mean that they will issue the LMIA in 1.5 months, but some sort of activity will occur usually in 1.5 months. So the next question is that now I am in Canada. So this is from Sania Khan Kabir. And now I'm in Canada with closed work permit. So in my immigration form, by mistake, I put unmarried, but in that time had a son. My question is, for the mistake will create any long problem to get my PR. So I cannot comment on your specific case because this is a very sensitive issue. Misrepresentation is huge. And you cannot simply say that I mistakenly didn't mention that I'm married and I have a son. I don't think any officer will buy into that unless you have very strong reasons, convincing reasons to convince them that why on earth you suddenly forgot about your wife and your children. So I would suggest that you book a consultation session with me. My consultation sessions are not free. The link for consultation sessions will be on the bottom of this video, but we will look into that. I'm not there to assist you to lie to the government. I will never definitely do that. But we can explore different potential options that you have, because sometimes you could apply for a TRP, sometimes you could apply for protection, sometimes you could apply for forgiveness. It depends on the situation. There are some solutions, albeit all of them are extremely limited, but at least you need to resolve that, because this will plague you for the rest of your life. It's not something that you can just easily justify it. It's up to you. You're not obliged to book an appointment with me, but if you are, I just posted the link on the chat box. I will also post it on the bottom of this video when we are done and we can take a look at it. Okay, so let me take it. Okay, I still have another 5-10 minutes. So now I am in India. So this is okay. So I answered this question. The next question is from Olomuyiwa. And it says, I have a job offer with nomination in Manitoba under IMP in NACC, level meet cutter. I mine eligible for approval under 2 weeks. No, generally speaking, no. Under 2 weeks is under the GSS program, and GSS focuses on the job offers that are related to high skilled jobs. So normally it's not the case unless the province has some sort of agreement with the federal government to make that happen, which I'm not aware of that. So it says, Kartik, there is no counterfoil update in GC key for first file, and I have mailed IRCC New Delhi and web form New Delhi specific. I'm worried. Okay, so hopefully, Kartik, they will understand the situation and they fix the issues. Again, as I mentioned, they are human beings. They look into the things. And if they realize that the first application was withdrawn and the second application is active, hopefully they will process it the way that you want. Even if they don't, you may, after you receive your passport, you may get in touch with them and explain the situation, and hopefully they will fix it for you. Okay. Yannick says, thank you so much. I love your live Q&A. Oh, thank you very much for your great feedback. And yes, Sanya, John says, oh, okay. So that's my last question because I have another live session on Instagram in 10 minutes. So John says, hello, sir. Have you worked with clients from the Doha, Qatar area? Yes, I have. I have actually from Doha. I think no, not from Qatar, but I have had clients from United Arab Emirates, from Kuwait, from Oman, of course, from Iran, from Saudi Arabia, from Iraq, from Egypt, but not from Qatar. Sorry, first I said yes, but the answer is no, no clients from Qatar. But I have been to Qatar once. Okay, thank you very much, everybody. Again, every time I get a chance, I will go live from now on. I will discuss a topic. Today, I discussed IMP C42, and I will save it. You can watch it later. And then next time, I will talk another topic about another topic, and we'll come back and answer live questions as well. Thank you again for attending this live session. My name is Al Parsai. I'm a regulated Canadian immigration consultant. I have been active for the past almost 11 years as an independent immigration consultant. I'm the author of the book 88 Tips on Immigration to Canada. You can find it on any Amazon website. It has been identified as the bestseller on Amazon.ca under the immigration law. And I'm also an adjunct professor at Queen's Law, which is a university in Canada, one of the best law schools in Canada. I also teach at Ashton College. And as you can see, I do live, I do articles. Visit our website, settler.ca, and subscribe to our channel. See you soon.